Good afternoon, everybody. We have so much to cover here, but I do want to jump in quickly, but I do first want to thank our entire MMM COVID-19 task force, our incredible technology team, and particularly Jessica Rodriguez, Larry Coonan, Cecily Smith, Joe Hollahan, and Amelia Calloway for helping to put this together so quickly today. I'm Bonnie Hockman-Rothell, and I chair Morris Manning and Martin's litigation group. A little quick Friday afternoon humor to get us going. I was recently working with a junior attorney on public speaking and told that person the age-old adage to imagine your audience in their underwear. Well, let's just say you should all turn off your cameras right now. All right, jumping right in. Clearly, these are unprecedented and uncharted days for our clients, ourselves, our businesses, and our economy. The topics that we are focused on today have largely not been actively litigated. We have certainly seen force majeure clauses raised in litigation over the years, but never under circumstances involving such a quick approaching pandemic that included executive orders from over 25 states and more coming each day, businesses and establishments being required to close, and other stay-at-home orders being entered in amongst counties and cities across the country. So these are extreme and extraordinary circumstances. In some instances, some businesses are able to have business as usual, and in some instances, different force majeure provisions in contracts may be triggered, and many insurance policies may be triggered. So today's session is going to be focused on exactly what this all means. I want to put it in a little bit of context first. These new orders and ordinances and regulations that are coming out around the country often focus on what's an essential business. And we're going to have a separate webinar focused specifically on essential businesses and the suppliers that are providing work for these essential businesses. But I think it's important for the context of what is a force majeure provision and what insurance policies are being implicated to go through that real quickly. So there are issues that are being raised, such as what is an essential business? Can providers and suppliers for essential businesses still operate even if they themselves might not have been deemed an essential business? What happens if your business is deemed non-essential? Can my business continue to operate remotely even if it's not deemed essential? What if my business can operate? What are my obligations with those with whom I contract with? And what if a business I contract with can't perform or believes it's not essential? And then there are the overlapping contract provisions. What if you have a business that is deemed essential, but other entities that it's contracting with are claiming that they are not essential? What do you need to do? What do you need to know? And how do we prepare for what's coming? Listed here on this next slide, a list of businesses that most jurisdictions, and every jurisdiction is different, and you need to really know the jurisdictions we are following, and we're updating our website fairly regularly on the county and city ordinances and the states that have enacted something in response to COVID-19. But again, remember, this is changing rapidly and is very locality specific. But in general, grocery stores and pharmacies, healthcare operations, law enforcement, financial institutions, construction and skilled trades is an interesting one, but most jurisdictions, particularly if the construction relates to one of the other essential functions, essential businesses, is deemed essential. Residential facilities, hotels and motels, transportation, public works and utilities, waste management, and businesses that allow those essential businesses to operate. Again, this is very locality specific, and there are businesses that operate in multiple localities, so there are issues that they are going to need to deal with depending upon which of the many localities they're operating under. A lot of people, we're getting questions on a daily basis, what does it mean? What does the regulation mean? And in some instances, these state and local regulations don't have a lot of detail to them, and there's no precedent to interpret them. So we are looking at different guidelines to help us interpret them, and some of the localities have incorporated the Department of Homeland Security's cybersecurity and infrastructure security agencies' policies and guidances relating to the essential critical infrastructure workforce during this pandemic. In addition, different government agencies have been issuing guidance. We are looking at Department of Housing and Urban Development guidance, and there's more and more guidance being issued each day. So what is deemed to be essential is changing in terms of the interpretation each day, and we're going to need to follow it closely. So what does this mean? What does it mean if your business is interrupted as a result of one of those orders, or if your business is in fact allowed to continue? Well, first of all, let's think about some of the interruptions, what that might trigger. In some contracts, it may result in delay claims. In some contracts, it may result in work stoppage. There could be resulting losses. And so we need to, we're helping clients on a day-to-day basis figure out what are our clients' responsibilities, what are our clients' potential liabilities. Are these force majeure clauses in contracts being triggered? And is there any type of insurance coverage that will help protect against such losses? So that brings us to what is a force majeure clause. And it is very rare in litigation that you see a force majeure clause actually litigated. Force majeure clauses are very, very fact specific and very contract specific. They're also wholly dependent upon the facts and circumstances that are implicating the clause and state and local law and business around the environment at that time. So generally, a force majeure clause relieves a party of certain contractual obligations when performance becomes impossible or impracticable due to an event or circumstance that the parties could not have anticipated or controlled. Typically, force majeure clauses don't mention pandemics. There are some clauses that may specifically mention viral infections or health issues or pandemics, but generally they don't. Generally, force majeure clauses relate to a very time-specific event. For example, a fire or an earthquake or a hurricane. Over the past few decades, more and more force majeure contract provisions have been expanded to include such things more recently as market shifts, major strikes, terrorist attacks, computer hacking, and governmental action. You didn't see those types of provisions in force majeure clauses 10, 15 years ago, but since, well, I'm showing my age, I guess 20 years ago, but since 9/11 and the 2008 market and other major computer issues that have happened, you are now seeing some force majeure clauses specifically including those types of terms. Every single force majeure clause is different and each one has to be reviewed based upon the language in their particular clause. For example, some force majeure clauses excuse performance altogether. Some force majeure clauses allow delays or extension of time to complete performance. Some force majeure clauses might require that in order for the force majeure clause to be effective, the party must first attempt to mitigate the injury. In other words, it might have a requirement on the party that wants to exercise that force majeure clause to take some sort of action to minimize what the impact of the incident might be. And some force majeure clauses provide very specific notice provisions so that in order to trigger the force majeure clause, you have to give notice within a certain amount of time after the incident. So it becomes very important to evaluate your force majeure clauses now, even if you don't believe that your business is implicated or the entities whom you're doing business are implicated. You want to know what your force majeure clauses are and be prepared in the event somebody else tries to exercise a force majeure clause within your contract, or in the event your business needs to raise any of those types of issues. Sorry, I'm having a technical error. Just one moment. I'm trying to scroll to the next slide, and somehow I'm not able to. One moment, please. Oops. There we go. Sorry about that. There are a lot of different examples of what language you might have in a force majeure clause that might relate to the COVID-19 pandemic. Perhaps the force majeure clause contains specific language such as outbreak, disease, illness, epidemic, pandemic. Clearly, those might implicate your clause. Your clause may have something in it regarding an act of government. And in many localities, there have been acts of government. So we would need to review whether or not the clause is implicated there. Your clause may have language such as act of God or emergency. That becomes a little bit less clear, but also something that might be implicated. And then some simply say unanticipated events beyond a party's control. And that becomes something that is definitely left up to a lot of interpretation and discretion. Again, a force majeure clause does not automatically excuse non-performance, even if there has been disruption. For example, an applicable disruption may require that it still be impossible to perform. So you may have an interruption. You may have, an outbreak in your community, or you may have an ordinance that's enacted in your community, but those things might not make it impossible to perform. So your force majeure clause may not be implicated. We are advising our clients to stay informed, be really proactive, check your applicable supply chains, make sure you're aware of any export bans, make sure you just stay informed as to the economic environment surrounding your business. And then also equally as important, stay informed on how the local, national, and international governments are responding to this pandemic and how that might affect your particular contract. In some states, even if there is a force majeure clause in your contract, or even if there isn't, there may be some state guidance. I wanted to highlight two different types of applicable state laws. The first one that I've listed here is for Georgia, And the Georgia statute states that if performance of the terms of a contract becomes impossible as a result of an act of God, some impossibility shall excuse non-performance, except where by proper prudence such impossibility might have been avoided by the promisor. So the Georgia statute clearly ties the excuse to impossibility. But some clauses, and in fact most force majeure clauses, don't require impossibility. So in Georgia, in the case of Georgia, if you were operating under Georgia, if you have a contract clause, it might be a lot stronger. But if you don't have a contract clause, the Georgia statute is what might be applicable here. Again, acts of God are generally things such as earthquakes and hurricanes, not man-made acts. So that raises another whole issue as to what this pandemic might be deemed. By contrast, California has a very different type of force majeure statute, and the determining factor there is whether the particular event is claimed to impede performance could have been prevented by exercise of prudence, diligence, and care. So it doesn't have an impossibility requirement under California state law. So I've been talking with clients all week long about what type of precedent there is out there as to whether or not the pandemic would be deemed a force majeure. And again, it's going to depend upon the contractual provisions and what happens next and what our supply chain look like in our respective business arenas. But I did want to show a few examples here. This first slide talks about several incidents where a force majeure trigger was deemed to have existed. So the first one was where there were declarations of states of emergency in New York in the wake of 9/11 terrorist attacks. And in Bush versus Pro Travel International, the force majeure clause was likely going to be triggered because performance would have been impossible for a period of time. Likewise, when multiple hurricanes caused damage to a pipeline preventing delivery, a force majeure clause was triggered in Virginia Power versus Apache. And lastly, when there was an outbreak of a viral infection at 3 hog farms, which affected hog production, a force majeure clause was triggered in SNB. By contrast, though, there are also many instances where force majeure clauses are not triggered. So the global financial crisis of 2011 was deemed to have not triggered a force majeure clause where a restaurant had faced financial hardship. Again, under the specific facts of that case, which was Route 6 Out Parcels versus Ruby Tuesday, note that there are other cases dealing with the global financial crisis of 2008 where a force majeure clause was deemed triggered. Likewise, the avian flu outbreak of 2015 was deemed to not trigger a force majeure clause, where in that instance the avian flu didn't affect the supplier's ability to build and supply a commercial dryer that was being sought in that particular case. We have, over the last week, looked at force majeure clauses in construction contracts, escrow agreements, restricted stock purchase agreements, merger agreements, trust agreements, custody agreements between banks and funds, employment agreements, commercial leases, share purchase agreements, property rental agreements, and supply of goods agreements, amongst others. And each and every force majeure clause was different, and the analysis of each one very different under the current circumstances. I'd like to now pass this over to my partner and colleague, Larry Coonan, to talk a little bit more about force majeure application.
All right, good afternoon, everybody. Going to go a little bit more detail now into the kind of things that you see in force majeure clauses. Force majeure clauses have historically been thought about as more boilerplate clauses. You see them at the end of the contract. And I can tell you that as of about 2 or 3 weeks ago, I really didn't think I was going to be spending a majority of my time looking at force majeure clauses and applying them to different factual scenarios. And I've probably advised about a dozen clients so far on their rights under the force majeure clause, or some in reverse, which is they're concerned that a customer, for example, might use a force majeure against them. And this is in the one-time event context, an ongoing services context, a lease context, a loan context. And the answer is really different every single time, which in a way caught me off guard because, as Bonnie mentioned, usually a force majeure is a time-specific event. A fire occurred that destroyed a building. That's easy. An earthquake that occurred that destroyed a building or hurt a bridge that people couldn't get to you. And we're in an unprecedented situation where this epidemic is growing. It's changing every day. You've got local declarations coming out. You've got statewide emergencies coming out. You've got directives coming out of the White House. And so the rights are changing every day. And Bonnie mentioned a thing about notices. And it's like, when do you give your notice? When I have a fire, I know the date that it occurred. Here, it changes every day. And using an event as an example, it's one thing if I have an event scheduled at a hotel next month, which is definitely implicated by directives that are out there, versus something that may be a few months down the road, but you're already nervous about what your attendees are going to be doing with regarding to their travel plans, or what further changes might be happening. We don't know if this thing's ending in a few weeks, a few months. And so all of that gets looked at. So Bonnie had actually mentioned this first point on the PowerPoint, that the force majeure clauses are not drafted equally. And so you have to look at them with regard to the facts and also the state law that is at issue. And as I just mentioned, a pandemic is not the type of force majeure that we normally would see. And so we are in a very situation. I am now the one with having a computer is delayed, but I'm assuming you're still on slide 15. Mike, I assume you're still, oh, there it goes, okay. So there are a bunch of questions that we as lawyers and you as clients should be asking. You see a force majeure clause. I'm not going to go into in significant detail. They're here for PowerPoint. But first, does the force majeure clause require impossibility or just the lesser effect on a contract? We've seen both language. And by the way, I'm going to show you some samples coming up here in a few slides what different force majeures look like. But some say if your performance becomes impossible, it applies. Some say if your performance is materially affected, then it may apply. Does it relate to permanent or temporary relief? In other words, has the event literally stopped your business that you can never perform, or is it something that's just delayed, which is something that's coming up in, for example, finance agreements? And you may have already received emails from banks saying we'll work with you in order to delay payments if we have to, but they're not going to let you off the hook with the loan itself. Does act of God apply to pandemics? Open question. Bonnie mentioned that as well. And then what we're kind of reading the crystal ball on is what's the judicial tolerance going to be if these things end up in court? There seems to be sympathy on both sides. Somebody who hasn't done anything wrong is essentially losing their job, losing their business. And on the other side, you've got somebody who does have a right to get out of their contracts, even though that's going to harm somebody else. And that remains to be seen. And it's also possible that we're going to see further regulation talks about. Next question is, does the clause permit termination, suspension, merely excuse a failure to perform? I've read a couple of these force majeure clauses that say a party is excused from performance as a result of majeure. begs the question, what about the other party? If one party stops paying, in the normal circumstance, the other party doesn't have to continue to perform. But what if they're not paying because the contract said that they didn't have to pay? Does the other side still have to perform, especially if there's going to be an expectation that payment will eventually come? And this is something that may shake out with the stimulus bill that is going through Congress right now. Is the cause bilateral? I've seen one way. Force majeure clauses, incredibly, instead of either party may, it may say only the customer has a right to escape a contract for a force majeure. Language to look for, and we're recommending that people put this in going forward contracts. Most force majeure clauses say you could get out of a contract or delay your performance or be excused for performance for events including acts of God, fire, earthquake, natural disaster, government action. It would really help if you had this phrase, including but not limited to. Otherwise, that list could be considered the list that applies and not something else that could be interpreted to be a force majeure. And then again, the deadline for notice. So right now, there are some people who are wanting to put someone on notice to say, I want to get out of a contract because of the unknown in the future. And maybe that 10 days is triggered from a local declaration that occurred last week. You know, we've had declarations, including from the CDC, that say no more than 250 in a room, down to 50 in a room, now down to 10 people in a room, as long as you're 6 feet apart from each other. And so that's something that you have to look at inside the clause. Let's go through some examples, and I don't want to read all these in particular. Attention to the bold language. These are real clauses that I've seen in a contract. This one says neither party shall be responsible for unforeseen circumstance or due to a cause beyond such party's control, including but not limited to. That's a pretty nice broad clause that applies not to time-specific events, not to a particular circumstance, and it talks about responsibility for failure to perform. What's unclear in this one is permanent escapage or just while the event. Here's another clause, says the agreement is subject to termination without liability. So that one clearly says termination. Then it has this phrase such as, and it has that's not as good as including but not limited to. That could be interpreted as one of the and then is conditioned upon notice no later than 10 days after learning. Well, a new basis is popping up every day. And so what you don't want to have happen is you wait too long and then have the other side say, well, you actually knew about this a month ago, because that's when you should have triggered it. About it at first. Here's another sample. It says if a party's performance is subject to, and then it's a finite list, so it doesn't say including but it does have this language beyond the party's control, and in each case make it illegal or impossible to perform. Legal is interesting because government action could say you cannot conduct your business or allow people in the front of your business. And again, the terminating party has to give notice within a particular time. This next slide, there we go. This is a long one, and this is actually a fictitious clause. This is a new one that I put together from something that was pre-existing with where we might be going with these clauses, and I'm going to give the explanation as to why. It says no party shall be liable or responsible, nor deemed to have defaulted the agreement. Put in an exception for previously earned payments. That's something that I got a question on, which was somebody asked, well, I've already performed. It's already been accepted. They already owe me the money. Now, can they escape that? Well, depending on which side of the contract you're on, you might want to protect yourself there to say, if you've already accepted performance that I've done, you still owe that money. It has the concept of reasonable control. But then at the bottom, you'll notice this language as far as what's included in the list. Disease control, it's missing the word such, disease control such as virulent human influenza pandemic, similar influenza. Um, and it's also in the editing here, it says United States Center for Disease Control. It's supposed to be the CDC. Where that language came from, and I'm not going to get into the insurance issues, but I read an insurance policy where that language was excluded from coverage. And so the goal here is to make sure that the force majeure clause covers the gap between what your insurance might not cover, but allow you to get out of the contract so you don't face that damage and then you don't have insurance for it. So this one is just kind of, food for thought. I wouldn't say take this lock, stock, and barrel, but gives you an idea of the things to think about. So ultimately, and Bonnie mentioned this as well, you have to look at the provision. You have to look at the facts. As to what again, then be aware of other force majeure clauses. So, for example, customer cancels on you don't think the customer has a right to cancel. You start to get into a discussion with them, and then you realize that your supplier has a similar provision that says they're not going to get you the supply. Well, then you have this kind of trickle down effect of one contract's going to be terminated on you, which affects whether or not you want to terminate downstream towards your customer and vice versa. So just think about other force majeure clauses, and since force majeure clauses are not written the same, they may not be consistent with each other. So next steps before I turn this over, review your specific contracts, identify issues that could arise, keep lines of communication open with all parties. If the disruption has already occurred, the notice requirements. Always keep in mind a force majeure can be a recipe for negotiation, and I would say half the ones I've dealt with so far, that's what happened, was somebody invoked the force majeure and then the parties negotiated out what they were going to do. One example is an event at a hotel. If you'll let us cancel, even though we may technically not be within the government regulation yet, we'll reschedule with you in a later period of time, getting that business that you wouldn't have otherwise received from us. Perfect renegotiation. And then, of course, watch the legislation that may affect the operation of force majeure. And finally, check your insurance policies, which is a good segue for me to turn to. Oh, wait, there was one more I had to cover here. I'm sorry. I just wanted to point out force majeure is not your only way out. You've also got legal doctrines of frustration. I did see it, not that we're in question on the side about the effect on pieces and timeliness of performance. Well, many of us have seen contracts that are like liquidated or construction on time. Well, if you can't do that because of a government directive, you probably have a frustration of purpose that also kicks in outside of the force majeure itself. Keep in mind that there may be other doctrines that apply. That probably is its own topic that we don't have time for now. So at this point, I'm going to turn it over to Joe Holland. Insurance issues related to.
Thank you, Larry. We're going to turn now to insurance issues that are implicated by the pandemic, and I'm going to talk about the major coverage issues in this area. And then my colleague Cecily Smith is going to discuss some things you might consider if you think you may have a claim, or if you need to communicate with your carrier. If, for example, you anticipate you might not be able to make a premium payment and are concerned about your coverage being canceled. So where should we start? Well, of course, start by reviewing your coverage. And there are a couple things you may want to do now, even if you haven't suffered losses that you think you may be insured. But first, take a look at the coverage you have, and to to see what sorts of cover you might have that would be associated with losses arising from the pandemic. Another thing you may want to do is look for gaps in the coverage so that you're ready if we face similar circumstances in the future. You know, some experts are predicting that we may have one or more, additional periods when the population needs to practice social distancing or shelter in place. So we could have additional more episodes like we have now, and it's really not possible, of course, to get cover that's specific to pandemic at this point, but you might be able to fill gaps in areas where you would have other vulnerabilities arising out of COVID-19. For example, cyber liability. Now, with your workforce working from home, you may have additional exposure in that area. So you may want to look at your covers, see what kind of cyber liability and response expense coverage you have, so that you, and if you don't think you have adequate coverage, fill in that gap if you anticipate that you're going to have greater vulnerability in that area. Also, if you have a captive insurance company, if you own a captive or you participate in a group captive, you're going to want to look, if you own the captive, you're going to want to look at the captive's exposure and evaluate whether it's properly reserved for any increased exposure. You're also, if you feel that you may have coverage under a captive program, keep in mind a few things. One is if you do decide to pay a claim from the captive, you have to act reasonably when you do that, especially if you've elected to treat the captive as an insurance company for federal tax purposes. It's important that you maintain the integrity of the program and that you only pay claims that are properly within the four corners of a policy. Also, if you have reinsurance backing the captive, certainly you need to consider. You only should pay valid claims because if you're going to be relying on recovery from reinsurers, they're only going to pay if the claims were properly due and payable under the policy. Other things to consider, and we're going to talk about this in greater depth in the next few slides. Exclusions under the policy. Notice provisions, of course. If you think you may have a claim, it's going to be important to abide by the conditions for notice and applicable law. As we'll see when we talk about the business interruption cover, the law that applies in your state may be determinative of whether you have coverage. The other thing that's not mentioned here, but of course is very important, are your particular circumstances, because the extent to which you may have coverage is going to depend not just on the wording of the policy, your policy, but also your particular facts and circumstances and how they fit into that wording. So here are some of the key coverages that are implicated by the pandemic. Business interruption cover, and we're going to talk about that, and really much of my discussion will focus on business interruption cover. For a couple reasons. One, that's where we're getting the most questions at this point, and two, if there is coverage under business interruption, then there's a possibility of recovering some of the lost business income that may result from this. So that makes it particularly important. You may also have coverage for decontamination costs associated with if your insured premises are contaminated by infectious disease, by the virus or other infectious disease. Event cancellation insurance is important here. I'm not going to spend a lot of time talking about that in this session. We plan to have additional webinars in the future, and we'll drill down on issues like event cancellation and other specific types of cover. But because the event cancellation insurance is not very standard from insurer to insurer, it's hard to make generalizations about it. So if you do have an event that's been affected by the crisis and you have cancellation insurance, you're going to want your counsel to look carefully at the policy and make a careful evaluation of what kind of cover, if any, you have. Travel insurance is important. As I mentioned, cyber liability and expense it can be important in the current situation. I'm going to talk a little bit about workers' compensation, some things to keep in mind there. Looking forward, we're also going to look briefly at general liability cover. It's a little early, but we are already seeing some general liability claims. There's one against a cruise ship company alleging that it didn't take adequate precautions to protect its passengers from infection by the virus, and there's certain to be more in this area. So let's look at business interruption coverage. There are a few different types of coverage that may come into play here. There's the standard business interruption, which will provide compensation for lost income and what are called extra expenses associated with a disruption or interruption in business operations due to an insured loss. So this is designed to provide coverage where operations are either suspended or disrupted due to an insured event. There's also contingent business interruption, or what's sometimes referred to as supply chain, and that's the same kind of losses but associated with an insured event on the premises of a supplier, one of your key suppliers, or sometimes customers as well. Civil authority coverage also can be important here. This is insurance for losses that are associated with your inability to operate due to an order of a civil authority that restricts access to your insured property. And then some businesses, especially those in the hospitality and healthcare sector, may have business interruption coverage for communicable diseases. This is for losses that are associated with suspension of operations when the property itself is contaminated with an infectious disease. It may not apply just generally to cases where you have a pandemic in the community and you can't show that you actually had the presence of the disease on the insured property. But we'll talk a little bit about that. Business interruption coverage typically, and this applies to each of the coverage parts we were just talking about, typically it requires some direct physical loss or damage, in the case of standard business interruption, at the insured premises. But in the case of supply chain or contingent business interruption, the loss or damage typically is required at the supplier's premises. For a civil authority type cover, you're looking for some type of physical loss or damage usually it has to occur near the insured premises, and that gives rise to the governmental order restricting access. A real question here is, does contamination with the coronavirus constitute physical damage? Well, first, there are two related issues. One, do you have the presence of the virus at an insured property or supplier's premises? And you may. I mean, you might encounter a situation where an employee or someone else who's been on site is diagnosed with COVID-19, and that it's not clear, but that might be enough on the premise that if somebody was on site and we know that they were infected at the time they were there, that might be enough to prove that there was contamination at the property, but it's not clear. So if you have that situation, one thing you might want to do is test for the presence of the virus. Have someone who's expert in this area come in and do swabs and test, and keep that information. Even if you don't think you're likely to have a claim, you might want to do that against the contingency that you might at some time in the future have a claim and would want that evidence to present to your insurer. There are cases in this area, and there's a split among the courts, but there are some courts who have been willing to hold that where there have been contaminants found at a property, for example, like ammonia or asbestos or lead dust, that these things, it was enough that the property was temporarily rendered unusable, that fact alone was enough to constitute the kind of physical damage that would be necessary to trigger business interruption coverage. So in other words, it wasn't necessary for the property to have been altered in some way to show damage. Instead, it was enough just that the presence of this substance, whatever it was, made the property unusable. So it may depend on, it's going to depend on what the prevailing authority is in your state. Not all state courts have followed this, but some courts have, and those precedents will be important if you are making a claim for business interruption coverage. You'll have to pardon me, I have a bit of a cold, so I'm pausing from time to time to take a drink of water. Another important thing to look at is the exclusions in the policy. Many policies do have an exclusion for viruses or infectious diseases or even pandemic. But it's important to look at the exclusions carefully because not all of them will extend to the current situation. Some of them, for example, don't specifically mention viruses, and in that case, you may have some coverage. Or they may exclude pandemics, but only pandemics that are associated with certain specified disease, SARS, MERS, maybe influenza. But in those cases, the coronavirus is not a form of influenza. It's not SARS or MERS. So there may be a possibility you could have coverage here. One thing else I also might mention is that in some states, legislators have introduced bills that would require insurers to make payment for business interruption losses based on the fact that there's a pandemic and emergency orders have been issued. It's still early. None of these bills has passed or even come close to moving fully through the legislative process. One problem is that under the current situation, the legislatures have difficulty meeting to consider these things. But those will be worth watching, and those could be a game changer if one or more states were to pass legislation like that. Let's talk a little bit about civil authority. This is what's referred to as a coverage extension under the business interruption coverage part of a policy. Again, as I mentioned before, it is usually civil authority clauses require physical loss or damage in order to trigger the cover. And also just to mention again, this is coverage for business income losses associated with an order of a civil authority, and also extra expenses, other expenses that arise from the disruption to your operation. So for example, if you have to move operations to another site while your usual place of work is closed or inaccessible, or if you have to say pay to purchase technology to allow your workers to work remotely, those kind of expenses typically things that would be covered. Not all civil authority coverage extensions require physical loss or damage. In some cases, they're a bit few and far between, but I have seen clauses that didn't specifically require physical loss or damage. That might be a case where you could make a colorable claim for coverage. The same kind of questions that apply for business interruption also, when we look at whether there's physical damage, also apply for civil authority. What type of damage are we talking about, and where did it occur? Generally, another precondition of this type of cover is a order of a civil authority restricts access to the insured premises. So it's going to be, when you're evaluating this type of cover, the type of order issued by state or local authorities is going to be important. If it's just an order that encourages businesses not to open their doors or to practice other social distancing procedures, that's probably not enough to trigger the cover. It has to be an order that limits access to the premises. So an order that closes, requires non-essential businesses to close, that may be enough. And then again, as with other types of business interruption cover, important to look at the exclusions. There may or may not be a broad exclusion for infectious disease or pandemic that would apply here. Some policies have business interruption coverage that's specific to communicable disease. In my experience, at least, this is usually tied to contamination of the property with some type of an infectious disease. So it's not necessarily designed for a pandemic, but more specific to a case where you have you know that the infectious disease is present on the property. You have to close operations in order to decontaminate and clean the property. It like these other covers, it applies. It provides coverage for lost business income and extra expense. It may also apply. May also provide coverage for the cost of decontaminating the property, and maybe any public relations expenses that you might have in the wake of an incident like this. So let's just spend a minute talking about workers' compensation. Workers' compensation is the coverage that's mandated by state law that provides compensation to workers for occupational injuries and disease. It pays for medical expenses. It also provides some limited cover, oftentimes for lost wages. Workers' comp also has a coverage part that covers employers' liability that falls outside of the state mandated coverage. That's a fairly narrow slice of coverage but could come into play under these circumstances. In many states, ordinary diseases are excluded from the scope of workers' comp, and those are diseases that are acquired generally in the community. So there'll be some question as these claims develop. There'll be some question as to what does COVID-19 constitute? Is it an occupational disease, a disease that was acquired because of the function in which the employee was operating, or is it more sort of a disease that's generally present in the community? And that may depend on the type of worker we're talking about. Workers in the healthcare industry, first responders, these types of folks may in fact have workers' comp claims for COVID-19 infection. But others could as well. If other workers who have contact with the public and are required to have contact with the public throughout the pandemic, for example, workers in a grocery store, they may also have culpable workers' comp claims. It's important, because workers' comp is limited to work-related injuries and diseases. It's important if you have an employee who you think you know or you suspect has been exposed to the virus, keep careful records of where that occurred and when, and what was the employee doing at the time of the exposure, because those will all be important facts in determining whether or not there is workers' comp coverage. And then finally, let's talk a little bit about general liability claims. It's a little early in this cycle, but we are already seeing some claims in this area, as I mentioned earlier. And general liability covers liability for bodily injury or property damage that's suffered by third parties. This would be third-party liability claims for failure to take adequate measures to protect the public if they're on site at your premises or under other circumstances. It also covers product liability, and then it includes the coverage part for personal injury. And so we may see some claims for things like invasion of privacy. That's specifically covered under general liability policy. If there was somebody associated with the business, not an employee, employee claims are excluded under general liability, but others who might have been identified as having been exposed to the virus and didn't want to be identified, you could have an invasion of privacy claim based on that kind of factual circumstance. General liability also covers defamation, so you could have, under the same kind of circumstances, you could have a claim for defamation. You could even have, there have been multifamily complexes in New York where they've decided to empty the complex because it was known that the infection was present. That could give rise to a wrongful eviction claim. And also there's, associated with forced quarantine, general liability covers false imprisonment, and we could see some claims in that area as well. Here, as with business interruption cover, important to check the exclusions. Some policies have a general exclusion for viruses or infectious disease. So that's going to be important too. I'm going to stop there and I'm going to hand it over to my colleague, Cecily Smith.
Thanks, Joe. I appreciate it. Let's see. Here we go. So I'll move this forward quickly. So here's some food for thought. Again, my name's Cecily Smith. I'm a partner in the commercial litigation group, and I advise both insurers and insureds in coverage dispute matters, including representation of such clients if litigation is needed. So kind of wrapping up and following through with what Joe has said, as you see here, communicating with your insurer is going to be more important than ever, in the sense that I think that insurers are going to be looking at any verbal and written communication that an insured may supply to the insurer, looking for ways to either limit coverage or deny it altogether. And typically clients will, in some instances, allow brokers to at least initiate communications with insurers. I certainly would caution my clients, and I am cautioning them to allow that to happen in this instance, given how extraordinary it is and the number of claims that insurers are already seeing arising out of the pandemic. With respect to going forward with whatever coverage you may have, certainly I think that when your policies come up for renewal, and depending obviously on when that is, I certainly think you're going to see that insurers are going to demand that insureds buy endorsements to cover these types of pandemics, if that coverage is even offered. And certainly you will see in those renewals, I think, very different language, trying to exclude anything and everything related to pandemics. So just a kind of, again, best practice, definitely be having someone on your team writing herd with your broker, if you use a broker, to look at that language when your renewal comes up is a good practice. With respect to cancellation of policies, at least here in Georgia, the Commissioner of Insurance issued a directive last Friday that prohibits property and casualty insurers licensed in Georgia from canceling business interruption coverage for the next 60 days. So at least, until the third week of May, because of lack of payment of premiums. So if you're concerned that you may not be able to hold on to if you have business interruption coverage and may not be able to hold on to it because you can't pay the premium, you do have some cover there. And that directive is up on the Georgia Department of Insurance's website, or certainly Morris Manning can provide a copy to you if you'd like one. And I know I'm running through several topics, but there is quite a bit of information. I know we want to leave room for questions, but on this topic of notice, and Joe already prefaced that certainly looking at the notice provision is going to be critical. But here, first of all, don't forget if you have excess or umbrella coverage to put all carriers on notice if that's where you think you're going. You'll need to first figure out, is your policy an occurrence policy or is it a claims made policy? And most claims made policies now are really claims made and reported, meaning not only do you have to make the claim with the insurer, you have to verify that you have reported it and they have received that report of a claim. With respect to timing, if you believe that you have suffered insurable losses under the policy, timing couldn't be more critical. That's because Georgia, if you're in Georgia, it has adopted the minority view that if you don't timely notify the insurer of a loss, then they have been prejudiced by that and you have no coverage. The majority view makes the insurer there has been some prejudice to the insurer before coverage is denied for lack of timeliness. And what does that mean? What is time, what's timely notice? I mean, the law again here is, most policies and most courts, some policies use this language and a lot of decisions have interpreted that to mean as soon as practicable. And my advice to clients in this situation is if you think that you have had a loss and you have some coverage for it, whether it's the business interruption or any of the other coverages that Joe ran through, there really is no downside to going ahead and notifying the insurer, particularly if you are in the state of Georgia, so that you can prevent some sort of denial on basically an administrative, timeliness theory by the insurer. Flipping to, what's there? If you're going to make a claim, I think some of the things that you'll need to be thinking about are, that the insurer will come back and certainly want some sort of calculation or valuation of the loss, particularly if you're making that claim under a commercial property policy and a business interruption theory. And granted, I appreciate that may be difficult to quantify the total loss at this point, but certainly having someone in your team trying to track all of that and be in constant contact with the insurer is just the best practice with respect to that. I also want to just bring up for folks that lots of policies contain language that preclude pre-notice payment. So in other words, if you don't, anything you pay out prior to putting the carrier on notice, they're not going to pay for. So in this circumstance, for example, if you have to go in and clean your premises in any way or actually provide some very specified decontamination type cleaning and you haven't put your carrier on notice, you certainly, I think, would be in jeopardy and there'd be an argument that the insurer would not have to reimburse you for that. So obviously, again, best practice, keep top of mind any kind of payments that you're thinking about making prior to putting the carrier on notice. Also, going back to Joe's discussion of the civil order coverage, trying to, I think, task someone on your team with following all of the different orders and governmental declarations and how those are being changed and modified sometimes every day, week to week, is a great idea, especially if you're a multi-jurisdictional business, because I do think it's going to be harder and harder for insurers to deny coverage if you have that type of coverage, just based on some of the precedent out there in the insurance coverage world, just based on, for example, Hurricane Katrina, the wildfires that occurred out in the West last year that were so devastating. So you certainly want to make sure you are keeping track of all of those so you can document your case, good evidence of your claim. Hopefully this audience appreciates that once you make a notice or put in a notice of claim or a notice of occurrence with your carrier, the carrier will issue a coverage determination, and that just takes three basic forms. Either they're going to accept coverage, they're either going to acknowledge coverage but under a reservation of rights, or they're going to deny it. I certainly think here the best case scenario is that insurers may acknowledge coverage under a reservation of rights. And I think for precedential reasons, I do think carriers are going to, out of the gate, deny, if not all, the vast majority of claims made. But that should not, I don't think that should be totally informative of really what the coverage is. There's going to be a lot of science, I think, that's going to have to be developed that, for example, came out of the asbestos world that's going to inform the interpretation of the language in your policies. Certainly, I think that there are going to be a lot of analogies to be drawn, again, between the most recent large insurance coverage litigation out of the wildfires from California that I think will be helpful to insureds to try to gain coverage. And even keep, from a strategic point of view, I'm advising clients, even if you get a denial, that doesn't mean that you take that, of course, laying down that negotiating with the carrier, depending on what your losses are, to potentially enter into an early settlement for some amount of money on the policy instead of getting into a potentially protracted coverage dispute may be an option. And I think from my insurer clients, they are obviously thinking from a business perspective that settling early and not standing underneath an avalanche of litigation, may be a really good strategy from their point of view. I would caution, and I am cautioning my clients, that if you want to engage in settlement negotiations, the language in that settlement agreement and release needs to be looked at more carefully and closely than ever, in the sense that at least the epidemiologists and doctors out there that get on the TV every night are saying that there may be waves of these pandemics and waves of the COVID-19. So understanding that, I think the language that may be included in settlements and releases just has to be very, very carefully and thoughtfully written so that you don't shut the door if you settle with an insurer now and there's another outbreak that you would not be able to obtain coverage later on. Then the last part is, of course, if you have strong coverage arguments and you have substantial losses, there's always, filing a declaratory judgment action. Those are governed by federal and state statutes, depending on where the jurisdiction would lie for your lawsuit. There are, in all policies, suit provisions that have to be followed if you're going to sue your insurer. So that's very important to study. And then also thinking about it beforehand, and this goes back to something Joe mentioned, the conflict of laws issues that may be here. For those that are in Georgia, as an FYI, Georgia applies the traditional choice of law rule of lex loci, and with insurance contracts, they are constructively made at the place where a contract is delivered. And Georgia courts at least have determined and interpreted delivery in slightly different manners, and it can mean delivery to the insured or to an agent or a broker of the insured. But that will certainly want to look at that, because obviously Georgia is a pro-insurer state, but not all states are that way. So certainly looking at the conflicts of laws issues may be important if litigation is somewhere that you may need to head. So that, I know that was a lot to take in. I'm going to turn it over now to my colleagues, and we'll take questions. So Bonnie, I think we'll start with you if you'll take a question and head off with it.
Yes, thanks, Cecily, and thanks, everybody, for the great presentations. A quick shout out to those of you who have written me over the last hour to confirm that they've turned off their cameras. I do appreciate that if you were there for the beginning. But anyway, I'm going to take the first question, and the first question is as follows. Would a force majeure apply to allowances in leases? For example, an allowance for construction that can't be completed because of the city. That's a really good question, and the reason I want to take that one first is I've actually been talking with several clients about similar situations over the past week. First of all, the short answer is it depends, and it really does. It depends upon quite a few things. I am assuming from the question that the construction cannot be completed because the city offices are either there to, are not available to give out permits right now, certificates of occupancy, or permits to perform work. But in this particular scenario, you would want to look at whether those allowances are truly being hindered and at the moment or simply being delayed. In other words, if you already have occupancy of the building and you can't get all of the allowances because you don't have the COO, then I would think that it would be a possibility that this would be a scenario where it would be more likely that you would want to negotiate with the landlord, or if in fact you're the tenant in that instance, if in fact you're the landlord and you're being asked by the tenant for a concession, that might be a scenario where a negotiation would need to take place. There's also scenarios here where the occupancy itself is being deterred, and there are in turn business that's going to be delayed as a result of the lack of occupancy and consequential damages that result from that. So there's certainly an analysis that would need to be made of the specific force majeure here. It certainly seems like, depending upon the language in your particular force majeure and the facts and circumstances circling around why, whether or not the delay in construction, if it's a renovation or if it's just part of the space or the entire space. There's just so many different issues that would be involved here, but it is certainly something that might be triggered here. And in many instances, the inability to get a certificate of occupancy for a building or the inability to get a permit to perform construction could easily trigger a force majeure clause. In this particular instance, though, I'd also make sure you look at what the state and local rulings are that are coming out at the time. For example, some of the jurisdictions are allowing, I'm hearing temporary certificates under certain circumstances. I'm also hearing that there, obviously is rental relief in some instances that's being state and locally provided. So you want to look at those issues too. Hopefully that answers the question, and feel free to reach out offline if that didn't. I'm going to pass it off now to Larry to take the next question, and I understand Larry has better miking now. Larry, are you there? Maybe we should move to Joe. Oh. Why don't we move to Joe?
Well,
and then
while we're waiting for Larry to get to work on his mic, there's a question on workers' comp, and it's a good one. It's asking about whether there may be workers' comp claims arising out of employees who are working at home. Injuries that might occur while the employee is at home, as opposed to something that's directly related to the virus. And the answer is yes. There have some workers' comp boards have ruled that an employee, for example, someone getting up to go to the kitchen to get a cup of coffee who slips and falls, is doing that during the course of the workday, that can be a compensable claim. And so this will be coming up. It's a good practice to have safe work at home policies and procedures. although, as a practical matter, sure, it's difficult to exercise control over your employees when the entire workforce is working from home. But it's an excellent question, and the answer is yes. Some of these will be considered work-related injuries and would trigger workers' comp cover.
Can I be heard now?
Try? Yes, you can.
Okay.
I'll turn it over to you.
Hopefully this works. I'm trying this both on phone and the computer. So answering the question about hotels, this is a question that's come up a lot. And it really depends, number one, on the language of the force majeure, the language that's in your cancellation clause. And then finally, how far out are you? So I've dealt with conferences that are coming up in the next week. Those were somewhat easy. There are conferences that have come up in the next month. Those were easy and renegotiated. There's one I've been dealing with recently where the conference is not occurring until the end of the year. And so there's pushback on that one because it's way too early for the hotel to say, you don't really have a force majeure yet. You still got 6-7 months to go. So it really depends on what you see in the contract itself versus what the current directives are coming out of the governments and the CDC. And if you want me to look at your clause, I'd be happy to do so and let you know what I see there. All right, who's got the next one?
Cecily, can you still hear, or is it back down to me?
I think it's to you, Bonnie. I think there was a guarantor question that needed answering that's in your wheelhouse.
Sure. So I think that somebody has asked, could one of you discuss the issues concerning guarantors in the context of non-payment by the primary party and collection of the underlying obligations against the guarantor? Would the protection of the force majeure clause apply to the guarantors also? Again, this is a maybe. I think that you're going to need to look very carefully not only at the language in the force majeure clause, but also the language in the guarantee agreement itself. So the guarantee clause may be an absolute guarantee, or it might only be dependent upon the primary obligor's obligation to perform. In addition, the guarantee language might be much narrower. In other words, it might only be triggered after a certain period of time. And if the force majeure clause only provides for a delay of an action, then perhaps the guarantor likely, the guarantee would not be triggered in the first instance. All of that being said, there's also certainly scenarios where the guarantee might be triggered by the underlying obligor's excuse or delay as a result of the force majeure. So just to give you a quick overview, there are, in fact, case law precedent out there finding that a force majeure clause or a force majeure event doesn't equally make the guarantor's performance impossible. So there might be instances in that, as that case was finding, that even though the underlying obligors it was impossible for them to perform, that doesn't necessarily mean that the guarantor's obligation becomes impossible. But then, on the contrary, there are some cases out there which have arose where the guarantor is excused. I think another thing you need to look at is when did the obligation of the guarantor arise? In other words, if it was an obligation which arose prior to the force majeure event, or an obligation of the guarantor that arose after the force majeure event arose. So another excellent question, and I wish there were a clear answer, but you would want to very specifically look at both the guarantee provision as well as the force majeure provision in that particular instance.
Thanks, Bonnie. Oh, go ahead.
Oh, no, I was going to hand it back over to you, Cecily.
Well, I don't, Larry, Bonnie, any more questions? I think I've lost the ability to see the questions. I'm not sure if there's any that we still need to answer, because I know we have only a few minutes left.
Yeah.
Don't see any more insurance.
This is Larry. There was one more question about impossibility and whether that applies. And the answer is yes. Common law doctrines of frustration of purpose or impossibility would still apply even in the absence of a force majeure clause. And that's especially true in like Georgia, where we have a statute on that. If a party absolutely cannot perform, that can form a defense to a contract.
We also have a request for us to send the slide deck to the participants after the call, and just want to let you know that we'll make sure that that's done.
I think there was another question or two that came in very recently. I'm reading them as we speak. The first one is, where force majeure provisions specifically exclude rent payments, are there any other tools at statute or common law that can assist a tenant? That would be a scenario where, first of all, there may be some common law ability, depending upon what state or locality you're in. And I think I mentioned earlier that there are some states and some local ordinances that are allowing for delays in or maybe lack of penalties, I think is the word, for late payments right now. And there are certainly jurisdictions that are prohibiting evictions at the moment. But depending upon where you're located and the type of lease at issue, there may, in fact, be something at common law or ordinance that might be triggered here. I can tell you also that it is, in some instances, an opportunity to negotiate if, in fact, it's a short-lived difficulty to make that rental payment. Anybody want to grab that last question?
Larry, can you take on that last question with respect to, I think there's one about specific clauses or language that you would recommend in updating contracts if there are multiple waves of pandemics?
Sure. And this dovetails a little bit into what Joe talked about with regard to insurance coverage. If you put in a claim and then the wave keeps coming, whether that's going to affect a future claim. But with regard to the contract itself, being that there might be multiple waves, a clause, and I honestly have not drafted one of these, it's a great question, but the clause could simply say, to guard against that, that the clause continues to apply should there be further waves of whatever is the event. So let's think of the classic fire. You know what the fire is, you know it's shut down, somebody comes in, they're now repairing the place, and as a result, they find out a secondary damage. That event actually dates back to the first one, or maybe during the repair, something happens that causes further damage. It's a whole new event. And you could just simply put in language in your force majeure clause that says that it applies should further events come around, and something along the lines that would guard against the local declarations that we're seeing. Another declaration comes up that you could then adjust what your rights are on the force majeure. That dovetails also back to the notice provision I talked about, which is what's the event of the trigger for the notice, and then a week later there's another declaration, then a week later there's another declaration. Now, my honest opinion is you probably don't need that language because each event in and of itself becomes an event you have to look at for the force majeure, but there's no downside to adding some saving language that it's not a clause that you have to invoke only once should something further occur.
You might also, we recently had an experience where client's vendor was moving, was handling confidential information, personal information, and because of a lockdown in the vendor city, they had to move to having their workers work from home. And so one thing we did make some significant alterations to the contract. We took some liability limitations off for exposure to security breach. You may also want to make sure that whatever they're doing, that you require that whatever they do, if they're moving workforce to off site into their homes, that that's consistent with their cyber liability coverage. And there could be other coverages that are implicated here as well, where you want to make sure that you're requiring your third-party business partners to have adequate cover and remain within the terms of it.
Real quick, I want to go back to one thing that I said earlier and make sure I clarify. When it comes to force majeure provisions, I want to make sure we emphasize that it's rare that they're extended to purely monetary obligations. So the obligation to pay rent is generally not covered, and that, while commercial lease forms often, will differ significantly, certain things such as the unavailability of receiving utility services or an embargo resulting in the stoppage of goods or services, those are things that that might trigger it here, but the mere fact of the pandemic may not. Really, you'll need to look at your lease agreements very carefully.
Okay, well, I think we're at the end of our time. I want to thank again all of my co-panelists and Amelia and Jessica's just incredible efforts to pull this together. And of course, thanks to all of you out there who have tuned in. Let me see if I can get there we go. So the for Morse Manning, we have a easily clickable tab on our homepage that will provide you with all sorts of information related to our COVID-19 task force and the myriad of issues that are arising out of this pandemic. So we encourage you to visit that. And certainly, if once the PowerPoint is circulated, all of our contact information for the panelists is there. So please feel free to reach out to us with any questions that you may have. And again, thank you. And I wish everybody a healthy and sane weekend as we all continue to hunker down during this crisis. Thank you.
Thank you all.